So we are in the midst of an AI revolution within the legal community, and we're here at AMC. I am Brent Hafe, the Practice Management Advisor at the State Bar of Wisconsin. We just got finished listening to our guest plenary from Judge Scott Schlegel of the Louisiana Fifth Circuit Court of Appeals. He presented with Professor David Kemp on using artificial intelligence with both the benefits and risks in mind. So thank you for coming up to Wisconsin. You stayed your first time here, so welcome.
Well, thanks for having me, Brent.
And could you kind of just give a kind of an overview, key takeaways of what you and Professor Kemp spoke about in your opening plenary?
You know, as you mentioned, AI is the new shiny object, right? I mean, we as lawyers and judges have been dealing with technological revolutions, for many, many years. Think of Dropbox, emails, fax machines. This is just another technological revolution within the justice system. And I think the big takeaway is we've done this before, we can do it again. Certainly it's different this time. Certainly the type of technology that we're talking about has significant benefits and significant risks that we need to look into. But we've been here before, we're gonna get through it. And I think that would be the biggest takeaway is that, just start learning how to use the tools, play around with them in a setting that you can't hurt anybody, Draft a song, draft a letter, use it to plan a trip, but start playing with it, start using it so that when it comes time to implement it in your practice or in your chambers, you have a good idea of the risks and benefits that you should be looking at.
Sure. And that's great advice, because this technology, I feel like, differentiates itself a little bit because of the speed at which it's hit the legal industry. Usually, we kind of fall behind a little bit, and we are a risk-averse group, and we kind of tread slowly into the great wide open of now AI. It's here. I mean, as you said in your talk, we're not even 2 years into this public release.
Not even two years into it.
And here we are, at a legal conference speaking about it and talking about how to use it with attorneys. And the speed at which it's moving, and also the ease at which you can just jump on and start using it, I think is the other fear. So thank you for bringing it to the forefront and talking about it. And it's interesting to hear from you as a judge, because if the legal industry moves slow, and pardon me if this is a misconception, but the judicial system, it moves slower in terms of implementing new ways to do things and technology. You're one of the judges that are out there always talking about, in all your different formats and ways to communicate with the legal industry. Why do you feel it's so important to use your podium as a judge and your understanding of technology with what we're seeing in this revolution?
As I said before, AI is just the shiny new object, but we've been trying to find ways to modernize the justice system for many, many years. And if you've looked at the work I've done in the past, it was using simple off-the-shelf technologies to make the justice system more efficient, more effective, and more accessible. As a prior trial court judge, I would handle 100 cases on the criminal docket, and we would tell everybody to show up at 9 o'clock. And what does that look like? It's absolute mayhem. I can handle one case at 9 o'clock. And so what did I do? When I became a judge, I started using online calendars. And I started staggering dockets using a product that cost me $100 a year. And that way I could cut down on failures to appear. I could send texts and reminders to criminal defendants so that we didn't pick them up and have to issue warrants for their appearance. And that was using simple technologies that folks are still not using. And so while we're looking at the AI, I hope what the AI conversation is doing is actually awakening the justice system to the benefits of certain technologies in certain situations, so that we start implementing basic technologies so that when AI and Gen AI is really ready to go, we have a very good technological foundation so that those risks that we talk about won't be so risky.
Sure. That's great. I know from following your work that you see the generative AI and its uses in deepfakes, and often we hear the word deepfakes and instantly you think bad,
Right.
Scary, bad, watch out.
Right.
You present a good flip side to that there are some really interesting positive uses that will help with the access to justice problem.
Yeah.
So how are you, I guess, displaying, implementing, and thinking about that as a help to greater improve access to justice within the judicial system?
Well, let me start by reiterating bad, good, scary, all those things that deepfakes are. The authenticity of evidence scares the heck out of me as a judge. And we can go down that road, and I have gone down that road. But let's talk about the positive use cases, because again, when you look at the justice system in general, and I'm typically referring to state courts around the country have very little budgets. They don't have much money to assist in this area. So some might have, the papers that are just somewhere in the courthouse that help people through. Some people might have a self-help desk. Some people might actually have lawyers that actually are in the courthouse, 4 or 5 days a week to help people with going through all these forms. It's not the reality in most places. In most places, most courts lack a website, and that's part of the low tech that I talk about. But most websites are not manageable. You can't even find what you're looking for, especially on the court's website. And so if we use AI and generative AI, because there is a distinction, as you know, we can start using it to go through all those handbooks that we all have in our courthouses around the country. Simple name change, simple divorce. Those things haven't been updated since the 80s. And so why are we not taking these old PDFs, using Gen AI to clean them up, to get better language, to update them, and then creating videos using deepfake technology to explain the process? I'm not talking about UPL. I'm not talking about practicing law. I'm talking about helping people walk them through the system. When a subpoena goes out for jurors, it says a few things on there. Parking, $5 here, show up here. Why are we not taking that, putting a little QR on it, and creating a video on the back end that I used as a clone video because it costs next to nothing. I don't have to pay actors and actresses, which we don't have the money to do that. Why are we not sending it that they can actually click on the QR, takes them to the court's website, and it's, a version of Brent saying, hey, thank you so much for your service to this community. I just want to help you make sure that you're comfortable as you come here. And when you come to court, make sure that you were properly attired. It's cold in our courthouse. Make sure that you bring a jacket with you. Parking is $5 in this area, $3 in this area. Make sure that you come and understand to tell your employers that you're going to be here for possibly a day, maybe a week. And just use these videos that we can use ChatGPT to script out to create these videos for, and be able to provide reasonable, accessible information to people that we can do in any language. You've seen my examples. I don't speak a lick of Spanish, but if you go to judgeschlegel.com, you'll find me speaking Spanish. And it's a touch of a button. And I'm not saying replace humans. If you can afford humans, use them. I have law clerks. I would never trade my law clerks for ChatGPT law clerk that I can build out. Never, ever, ever. But it's a way to layer on top of the justice system to help scale the justice system and help make it more accessible when you don't have the other resources. And the vast majority do not have the other resources.
Yeah, that's a great point. I guess playing off of that and taking it one step further, just earlier this month, we heard a concurring opinion from, I think, was it 11th Circuit Court of Appeal, where the judge took it upon himself to write a concurring opinion for the sole purpose of explaining a process that he used to a tool, if you will, to get at an answer to a very core issue within appeal before them. So could you talk a little bit, one, about that, and then how are you seeing things like this? Is this the first of its kind that someone has been outwardly, overtly saying, I have used this? And then where does this go within the courtroom? Like, where could judges be? Where should they be using it?
Yeah. So for the audience, what Brent's referring to is a federal judge on the Louisiana, on the 11th U.S. Circuit Court of Appeals, issued a concurring opinion wherein he explained his usage of ChatGPT to define the ordinary meaning of landscaping. This judge did not care for the dictionary's definitions, and he was in a circular argument with himself about the ordinary meaning of landscaping. To the judge's credit, he said, look, this doesn't matter for this concurrence. This really isn't an issue, and it wasn't. I'm doing this in the open so that we can have this debate. So I appreciate the fact that the court issued that concurrence because we're now all talking about it. With that said, I think it's an inappropriate use of ChatGPT or any LLM for that matter, because you're abdicating the judicial decision-making process when doing it and using it in that manner. Can you use AI and Gen AI to do legal research within chambers? Those tools are here, perfectly acceptable. Should we be using them to define the ordinary meaning of landscaping? I subscribe no. And I say that because we, the court, are bound by the record in front of us in that case. And so going to find the ordinary meaning from ChatGPT is like asking a third-party expert, well, it's asking a trillion third-party experts what their thoughts are on the ordinary meaning, because I can prompt it to answer it in any way I can. I can use it for these things. And some people might suggest that that's appropriate because the judge is just working through his or her thought processes. I, again, and some would argue that it's ex parte because whose ordinary meaning? And you're going outside of the record. We can't use Google. We can't use Google Maps. We can't use Wikipedia. We can use the dictionary because the rules say that we can use a dictionary. And in the state of Louisiana, we can talk to outside experts if we tell the parties that we're doing it and if we give them an opportunity to traverse that expert. Okay. So what are we going to do? We're going to say, hey, I use ChatGPT. Go for it. Yeah. It's not repeatable. It's not going to say the same thing, but what does Bard think about it?
Right.
You know, what does Grok think about it? So, you know, I think that is a step too far on the usage of these in chambers. Okay. I know that some might disagree with me, but to me, that is going outside of the record.
Yeah. Well, as you said, though, but the good that came out of issuing that, and it's a fairly lengthy.
Yeah, it's like a 30-page concurrence.
It raises all of these questions that we really need to be talking about. Right. So it did that.
Yes.
But as my role as practice management advisor, I hear a lot of questions, a lot of concern, what should I worry about, what should I be doing, what shouldn't I be doing, all of that, all around the LLMs. And one thing that I've been hearing quite recently is often from family law attorneys that are concerned about evidence that a client brings to them, and whether it be photographic, audio, video, and they're worried about taking that evidence and then, one, how do I know it's real? Right. And two, you know, how can I submit that to the court and make sure that this, you know, I'm not knowingly submitting any fake evidence to the court. So is there anything that we can do now as attorneys? You know, all of this is evolving so fast, as most technologists say, this is as bad as this is ever going to be. So, and it's pretty darn good, and you know, you could fool a lot of people with stuff. So what can we do now as attorneys coming to the court? And then with your experience from the court, from your perspective, what can the court do better and make sure in order to authenticate this type of evidence?
Well, court's perfect. Let's start there.
Well, of course. I should have suggested otherwise.
You know, this is a real thing. You know, the whole deepfake evidence is real. I mean, audio, video, and photographic. Audio scares the heck out of me. I was a former domestic violence prosecutor. Protective orders, as a trial court judge, we sign them all day, every day. And Brent, you've left me a voicemail, so I own you. I can clone your voice in 2 seconds and, you know, do anything that I want with it. And the vast majority of people can't tell the difference. And as they say, the tech kind of sucks today. You know, in 6 weeks, probably, they're going to add breath, they're going to add pauses, they're going to add the ums and the hahs. So it's going to get better and better and better, and it costs next to nothing.
Yeah.
And that's the distinction between today versus yesterday. Yesterday, you had to know how to use Photoshop to Photoshop. Today, you just push a button. Photographic evidence, these new phones, Apple just came out with its cleanup feature. Google has the magic eraser already, so you could take a picture with your phone, erase that person, change that person's positioning, change different objects within it, whether you're looking at an accident or not. And these are real issues. The video, what's on the market today for you and I, still, you can tell. I mean, it's good, but you can still tell. But the photographic evidence and the audio evidence today scares the heck out of me as a trial court judge. And so what are we going to do about it? I'm not a big fan, and you've heard this before, I'm not a big fan of the court orders ordering lawyers to disclose the usage of AI. Once the New York hallucination case came out, judges started issuing those orders. I wasn't a big fan of them, and as you know, I wrote an open letter to every judge saying, please do not do that. I think that the current rules and the current code of professionalism addresses most of that, candor to the court, what you owe to your clients and everyone else. There is one rule that I think should be modified, and an additional rule, and that is specifically ABA's Model Rule 3.3A3 and the state equivalence. And it says, a lawyer shall not knowingly offer false evidence. I think it should just be knew or should have known that it was false evidence. And what do I mean by that? Smoking gun evidence that your client brings you on that domestic case, and you're like, I got that sucker. Let's do it. I think you now have to pause as a lawyer and look at that and start asking your client tough questions. Where'd you get this from? It's not like they're going to bring the phone in that has the photograph that they took and you can go look at the metadata on it. No, they went to CVS or Walgreens, printed that photo and said, here you go, Brent, that's the evidence. Yeah. And that's easy to offer when you go to court. Like the mark plaintiffs one. Have you seen this, before? And if so, how? Yes, I took that photograph 3 weeks ago. That is, Scott, and that is him doing X, Y, and Z. Has this been modified? And of course not. No, it hasn't. And if you don't have the digital file, how do you cross that? And then it's going to be admitted into evidence. Same with the audio. That's Scott's voice. That's Brent's voice. I know it. I've been married to him for 25 years. Yeah. So I think lawyers should be scared of this, and courts should be scared of this. And so I think lawyers have to function as gatekeepers as well as the court. I think lawyers have to take their duty as officers of the court a little bit higher of a duty now to say, where'd you get this? Where is it? Start subpoenaing phone records right off the bat. Start asking for the digital files right off the bat. And if they don't have them, then you have to make the call. Again, you can't know everything. That's never been the duty. It's knew or should have known. So if your client gives you the smoking gun that they just found in the drawer 2 days ago because they just got deposed last week, you should have known that they just went and created that. And make sure that you do all the necessary things that you need to do that's reasonable before you walk into court and offer it as evidence. Additionally, I think there should be a higher duty on lawyers who walk in and use what we call the liar's dividend. This came out when the CSI shows first came out as a prosecutor. When the CSI came out, it ruined my life and every other defense attorney and prosecutor's life around the country, because we cannot get a latent print off of that ice cube. And our voir dire's turned into 3 hours. And that's what's happening now with the, TikTok just came out with Symphony avatars that you can create deepfakes for your TikTok videos. It's going to say AI generated, but what's going to happen is, because it's such a large platform, everybody's going to see deepfakes in every video feed that they look at for hours a day. So they're going to be very critical of any video evidence and any photographic evidence immediately, just like the CSI effect. And so I think lawyers have a duty not to run in there and say that's fake unless you have a reasonable belief that the evidence being provided by opposing counsel is fake. And if you do it and you didn't have a reasonable belief, it's sanctionable, because the sanctity of the justice system is far too important to say it's a fake. Yeah. Because you're playing off of everybody's now expectations and fears, and that's, the integrity of our justice system is everything.
Yeah, absolutely. Well, we live in interesting times,
do.
don't we? And it's changing so quickly.
Yep.
I thank you for being here. I thank you for sitting for the interview, and enjoy the rest of your time in Wisconsin.
Thank you, Brent. Appreciate it.